Hello, I'm Davina Gibbon. I'm a partner in the commercial disputes team at RPC, dealing with a variety of commercial and financial cases.
And I'm Parham, Kouchikali, also a partner in the commercial disputes team, and I focus on financial services litigation.
So Parham, we're here today to talk a little bit about the new disclosure pilot that came into force on the 1st of January this year. Disclosure has always involved a balancing act between all of the different interests involved, between the claimants, the defendants, and the interests of the court in progressing cases in an efficient and cost-effective manner. But the disclosure pilot is arguably seeking to change where that balance lies. How do you think that defendants are going to find it?
Well, I think for defendants, especially large organisations, one of the important factors is proportionality. I've spent a fair amount of time in-house at clients, large financial institutions, and one of the sort of key points is the extent to which you are able to get hold of documents and the burdens on the technology teams, the lawyers and so forth. So I think defendants will be looking to cut back disclosure as much as possible, and the disclosure pilot and the various models gives them as an initial tool ways to do that. So it'll probably be welcomed by the larger organisations who face these burdens. But I don't know, from your perspective, and I know you also act for claimants, how would international claimants sort of approach it? Because it might be a different lens.
Yeah, I mean, I think for claimants, the risk is very much that they might not be able to get the documents that will help support their case. So for a lot of claimants, and in particular international claimants, one of the reasons that they come to the English courts is because of the availability of disclosure, of getting documents from the other side which might be helpful to their case, and which isn't available in all jurisdictions. It's very much one of the aims of the disclosure pilot is to cut down the amount of documents that the parties exchange, and to the extent that that cuts down documents that are neither here nor there, then that's great. But claimants are still going to want to make sure that they do get the documents that will really support their case. That said, we're going to have to see how it plays out in practice and what the courts think of it.
Yeah, absolutely. I mean, I think that balancing is always going to exist. You're not going to please all the people all the time. And I think it's actually a good thing that the pilot says that actually parties need to make reasonable efforts not to dump documents which are wholly irrelevant to a case on the other side. That's encouraging. But on the other hand, you know, one of the parts of the overriding objective is justice of the case and the judge having the right documents in front of them. And that balance is always going to be difficult to achieve. So efficiency, proportionality, cost is always going to be something that has to be balanced. My sense is that technology will provide the solution. It's already beginning to do that. And I think that is the future in terms of solving these balancing issues.
Yeah, well, ultimately we'll have to see where it goes. We've got another 2 years to get through, and we'll be looking to see how it goes, sort of in the cases that we're working on. And if you want to talk further about disclosure, we'd be very happy to do so.